Hearing in the appeal, State Oil Marketing Company, Taurus Petroleum.
My lords, faced with this array of judicial talent, advocacy might seem to border on impertinence. So I'm going to try and be as short as possible.
Well, we were very impressed with the concision of your written. And that's meant as a compliment.
Now, a few opening remarks, if I may, my lord. As you know, the background, the context is a foreign award. Section 66 of the Arbitration Act, 1996, gives the English courts power to turn a foreign award into an English judgment. And the White Book provides that service out is permitted, pretty well without more. And that is that. SOMO is a state trading organization of a type with which the world and these courts are perfectly familiar. It's an independent legal entity set up by or at the behest of a state in order to carry out commercial operations in its own name in the international markets for oil. It is no longer suggested by the respondents that SOMO is an emanation of the state, nor that it acts in the exercise of sovereign authority, nor that it acts as an agent for an undisclosed principal, namely the state of Iraq, or that it holds property in trust for Iraq or anyone else. All of those have been run but have fallen by the wayside. As a matter of legal analysis, it acts in its own name and on its own account. It is, however, slightly different from a privately owned capitalistic enterprise. It may be capitalistic, but it's not privately owned. It's not there to make money for itself. It's there to procure the commercial exploitation of national assets and to participate in funneling the fruits of that exploitation back to the state and ultimately to the individuals who live in the state. Now, there's nothing surprising or abnormal about this. It's a commonplace characteristic of state trading organizations. Now, much emphasis in argument has been placed and still continues to be placed by the respondent on the fact that SOMO was not intended to be the ultimate beneficiary of the proceeds of the oil sales which it made. This is perfectly true, and the answer to it is, so what? This is always true of state trading organizations, and it doesn't lead to the conclusion that they're to be treated differently in civil law matters when they enter into the marketplace. The state of Iraq has ordered its affairs on the basis it would create an independent legal entity which would be sent out in the marketplace to incur obligations and earn benefits. And from that fact follow inevitable consequences. And it does not follow from the fact that a state trading organization is not intended to keep the proceeds of its trading activities, that it is not the legal owner of assets which it earns during part of their journey back into the coffers of the state. Now, all states want to ensure that the sums generated by the exploitation of public goods, whether through independent trading organizations or otherwise, return to the state to be used for public purposes. There will always be a desire to ensure that diversion does not take place before the fruits get back into the coffers of the state. And we have seen time and time again how that might occur given the state of corruption in the world and the various steps taken internationally and otherwise to prevent that happening. Now, there is therefore nothing particularly unusual or surprising if steps are taken in relation to a state trading operation to ensure that money is not improperly diverted and that mechanisms are therefore put in place to minimize the risk of that happening. What you get usually is a conduit designed to ensure that the money, when it is earned in the marketplace, passes back down a channel to get into the coffers of the country concerned. This is true in relation to someone like SOMO. It's equally true in relation to the Central Bank of Iraq. Central Bank of Iraq is not intended to be the beneficial owner of anything that comes in via the state trading operations. It is equally part of the channel by which money passes back to where it is ultimately used. At the end of the day, you might say money passes down the chain from the purchaser of the oil into the hands of the farmer who gets a subsidy to carry on his work. And there is a chain all the way down. At various stages, different people in the chain will own things, but that doesn't mean, and are not intended to keep them permanently, that doesn't mean that they don't own them. And it doesn't mean that ownership in the intermediate stages of the chain is not a genuine ownership in legal terms. Now, the particular feature that differentiates this case from what you might call a standard state trading organization where steps are taken to channel the money back in the right way, is that the setting up of the conduit initially was designed to ensure that oil sale revenue flowed down in a particular way, was brought about as a result of Saddam Hussein's invasion of Kuwait. So no doubt Saddam Hussein, prior to that invasion, had his own way of getting money in from oil sales. After the invasion of Kuwait, the international community imposed sanctions. Those sanctions have now gone away for the most part, but nevertheless, the state of Iraq keeps the conduit in place. But what your lordships will bear in mind is that the tin case, Rayner's case, tells us that whatever happens on the international plane does not create domestic rights and obligations on the domestic plane unless and until it is translated through domestic legislation. So the UN sanction regime may tell us why Iraqi oil proceeds were channeled in a particular way, but that channeling is done at the level of domestic law. Now, I emphasize that because the respondent's case would appear to involve the proposition that where the beneficiary of a letter of credit will not retain for itself the fruits of that letter of credit once it has operated, then the beneficiary is not the true, and that's in quotation marks, the true owner of the shows in action created by the letter of credit prior to those fruits being delivered. And they say the consequence of that is either someone else has to be the true owner, or that shows in action is in some way immunized from execution in relation to the judgment debts of the beneficiary. And if you look at my learned friend's statement of case, you will see that the word true or ostensible appears time and time again in relation to beneficiary, creditor, and even the debtor, i.e. the Crédit Agricole, although how they are not true, or the actual debtor in this case under the letter of credit, I know not. Now, with that brief foray into the background, let us look at the facts that we're concerned with here. For a number of years, Taurus bought oil from SOMO on the basis of SOMO's standard contract. So have Shell. Now, the standard contract is the same whoever's involved. So if I simply give you the Shell contract references, which are the ones which are relevant to this case, your lordships will find them in Appendix 3A, Tab 7, Electronic Reference 814 for the contract.
Sorry, give it to me, 814.
Tab Electronic 814.
Thank you.
For the contract.
Yep. Yep.
The way SOMO worked is that on, I think, an annual basis, they put Iraqi oil out to tender. And people who wanted to buy Iraqi oil would write back making offers, and SOMO would award effectively long-term purchase contracts. So, in Shell's case, they tended to buy it on a year-long basis. And so they would have a rolling year-long contract, and then they would send in their nominations and so on. And you have at page Electronic 814 the Shell contract.
Yep.
The particular Shell contract. Your lordships may look on page 821, you see payment. This runs over to 822.
Yep.
You've got the letter of credit. Now, that's the terms. Now, if you look at tab 2 in the same bundle,
Yep.
no, not tab 2. electronic page 750.
Tab 2, yep,
Is that tab 2?
it is.
Yes, it is. But it looks to me. You get a sample letter of credit.
Yep,
Standard form letter of credit, and that comes from Appendix 1 that SOMO issue to their standard forms. And if you look at tab 3, Electric 753, you get the annex containing the general terms and conditions. Article 2, page Electronic 755 is title and risk,
yep.
and there's an arbitration. So that's the setup. It's a perfectly standard setup of type you've seen all the way, and it is perfectly obvious that SOMO is the seller. Now, under the contract between Taurus and SOMO, well, under this general contract, the general terms, SOMO can be liable for demurrage and other expenses. They did incur demurrage and other expenses to Taurus over the years. In the early years, they paid. Suddenly, in mid-2005, they stopped paying, and they wouldn't even answer requests for payment. Arbitration resulted. An arbitration award was issued in February 2013 for something over 8.5 million, hasn't been honored, and here we are seeking to execute in order to get that. Now, the answer in our respectful submission to the issues in this case, and the letter of credit issues, can be reached by a straightforward application of the ordinary rules relating to letters of credit. Start with what is common ground between us. When a bank opens a letter of credit, there is thereby created a debt which is owed by the bank, and that debt is a shows in action, i.e. a piece of property which is capable of being dealt with as property and is capable of being executed against as property. Now, the essence of a letter of credit, its fundamental purpose, is that the opening bank, as debtor, promises to pay a defined sum of money to X, whoever that may be, as creditor. That is the heart and purpose of a letter of credit, the primary and necessary purpose. It forms the basic bilateral contract, which is at the heart of a letter of credit, and to which all other contracts which come into existence by means of the letter of credit are either supplementary or collateral. And I say all other contracts because, as your lordships will recall, letters of credit, those slightly arcane documents that you see, give rise to a whole series of differing bilateral separate contracts. You have a contract between the opening bank and the notifying bank. You have between the opening bank and a confirming bank. You have between the opening and confirming bank together and a paying accepting bank. You have it between the opening bank and the nominated bank where payment is to take place. And of course, you have a contract with a reimbursing bank, and you have various contracts with the beneficiary. Opening bank, confirming bank has made a contract, and so on and so on. So you have a whole series of independent relationships which come into existence, more or less depending upon the particular structure of the particular letter of credit in concern. You could have a very straightforward, simple one, but most of them tend to have various bells and whistles added on. And your Lordship, Lord Justice Moorbeck, who's seen many of these in his life, acknowledged that. Now, if, however, the primary contract, the contract on which, at the end of the day, all depends, it's the main purpose, is the promise by the opening bank as debtor to pay a creditor, the beneficiary, then it is obviously a matter of considerable importance that those two parties be clearly identifiable, particularly since the beneficiary will then, or may well then, move into a series of independent relationships with other banks, confirmation, nomination, paying, and so on. So, in the absence of clear identification, chaos is likely to ensue. So the first and primary issue is, who is the creditor under the letter of credit? Now, we accept, just to make sure that is well understood, that for us to succeed, the debt had to be owed to SOMO alone. If the debt is owed to someone other than SOMO, we fail because we are here to execute against SOMO's property. Equally, if the debt is owed jointly to SOMO and someone else, we fail because you can't execute against jointly owned property. And this has nothing to do with sovereign immunity or central bank immunity, or the status of CBI as central bank. This is simply a consequence of the law about executing, whether it's a third-party debt order or receivership. If it's not the sole property of SOMO, we fail. Now, three alternatives have been put on the table in this case. First, SOMO is the sole creditor because the primary promise in the letter of credit is made to SOMO alone. That is the conclusion reached by Lord Justice Moore-Bick. Secondly, SOMO and the CBA are joint creditors because the primary promise is made to them jointly. That's Mr. Justice Field. And finally, the CBI is the sole creditor because the primary promise is made to the CBI alone. Lord Justices Briggs and Sullivan. Now, before we turn to look at the letter of credit, I put one proposition before your lordships. There is a conceptual difference between a debt and the manner in which a debt is to be discharged, i.e. a promise as to the manner in which it's to be discharged. Now, let's turn to the letter of credit. Your lordships, if your lordship want an easy sample, but you'll find that in volume 3A of the appendix, tab 2, electronic 750. Yep. Our letters of credit that we are suing in relation to are the core volume 2, tabs 12 and 13, which is electronic reference 2752 and 2755.
Well, which one are we going to use?
Also in core documents, I don't know which bundles.
Well, we ought to agree now, you, Mr. Dunning, and the court, which we're going to use. Provided there's one that we all use, we'll know where we are.
Well, mainly because that's my marked up one. I would prefer core documents, part 1, tab 6 and 7, electronic 54 and electronic 57.
Is that, you content with that, Mr. Dunning?
Sorry, core documents, that's not the one you've just given us a reference to at flag 12 of...
No, that's flag 12 and 13, that's core volume 2.
So core one.
This core, appendix 1, sorry.
Core one.
Sorry, it's part,
Well, it's Supreme Court Appendix with electronic references.
part
It's that
1 of the Supreme Court appendix.
It's tab 6.
That's core documents.
Yep. It's Supreme Court appendices with electronic references, part 1, core documents.
Yep.
Are you content with that, Mr. Dunning?
You may find that tab 7 is a better copy, and they're materially identical, but the one at tab 7 is just a little bit easier to read than the one at tab 6.
Are they identical or materially identical?
I think they have different sums of money.
It's as I say, provided we all work from the same pages, otherwise we'll get in a mess.
So which one are we decided on?
Well, the one which Mr. Pollock had marked up, I think, was the one he preferred.
Well, that seems a bit...
It's the advantage of opening. I think you want us to go to 54, don't you?
My marked up one is tab 6, if it matters.
Yeah, well, Mr. Dunning
But
tells us...
since apart from different sums of money, they're identical.
Fine.
I really
Okay.
think...
Well, let's just refer to pages 1, 2 and 3 of this document, so we can work whichever page we want, provided we all know where we...
Now,
very well.
have that open.
Yep.
And no doubt, I imagine your lordships have looked at it, and you've got in here, and your lordships have seen this kind of thing before.
Some of us have.
A letter of credit, it is obvious, the state is an important instrument of international commerce. And although it is couched in language which to an outsider often appears arcane, its purpose and functions are extremely well understood. And the intention behind it is usually obvious. In a standard case of an international sale such as the present, where you have a monopoly seller, which you do in SOMO, the seller offers to sell on standard contractual terms on a take-it-or-leave-it basis, subject to price, which terms will specify that the buyer is to procure the issue of a letter of credit in a form dictated in those standard terms, which is what happens here, Appendix 2 to the standard terms of SOMO. So here is a letter of credit you have to procure. Now, it's quite important to bear all this in mind when you come to think about the way a letter of credit is put together. The buyer really has very little interest in the terms or form of the letter of credit, since as long as he procures the letter of credit in the terms required by the seller, he gets his oil and will, he expects, if his bank lives up to its obligations, have ensured the discharge of his obligations. So he doesn't care. He says, tell me what you want and I'll give it to you. So all the buyer wants is that his bank then should take the form which the seller has dictated and then issue it in that form. Because if it's issued in that form, then the seller is happy, everyone else is happy. And unless there is some arcane technical banking problem with the proposed form, the issuing bank will not itself care about the terms. All it wants to do is be satisfied that it is going to be in funds when it has to pay out. And that's done either by taking money in advance or with someone like Shell. I suspect there will be a rolling account between Crédit Agricole and Shell because Shell will use Crédit Agricole for all their international trading letters of credit. So when you bear that in mind, it should become clear how irrelevant and inadmissible is the background information which the respondents say should control the meaning to be given to the wording of this letter of credit. All this background information about Kuwait, the sanctions, and so on. There is not the slightest reason to suppose that the credit issuing clerk in the bowels of Crédit Agricole in the City of London had any knowledge of or interest in any of those matters, let alone that they had any effect on his mind as he issued the letter of credit in a form given to him by Shell, who had in turn been given to it by Somo, year after year after year. Now, it's the contention put forward by the respondent that the common intention to be derived from the letter of credit is to be boosted by a consideration of that background, and that means that the sole creditor of the letter was that the sole creditor of the letter of credit was supposed to be the CBI. That's their case now. Look at this letter of credit, think of that background, and it's clear that both parties to the letter of credit, and relevant parties are the issuing bank and the beneficiary, intended the beneficiary to be the CBI. One is therefore invited to suppose, and this is where the first absurdity of this argument arises, suppose that the Crédit Agricole, in the guise of the financial instruments clerk who issued this document, when asked to open a letter of credit in favor of Somo, which is what he was asked to do, was saying to himself, of course, we're not really promising to pay Somo, we're promising to open this in favor of the CBI. Now, you only have to state that to realize how absurd it is. Let alone that he would then take time in his rather busy day issuing many of these instruments to say, well, why don't I go away and look up whether there's an international background here that might in some way mean someone wanted something different. It's absurd. It just won't wash. Now, so that's, can you derive an intention on the part of the Crédit Agricole when they open a letter of credit expressly in favor of Somo, that what they really meant was in favor of the CBI? Now let's look at the other relevant party to this contract, which is Somo, whose draft letter of credit it is, who produced the draft. Now, what one is being asked by my learned friend's argument to assume is that when Somo, and I say Somo, although you have to have in mind that it may have been some overbearing American lawyer in the background, because as a result of the sanction regime, a bunch of Americans came in and told all sorts of people what to do things. They may have drafted the letter of credit themselves. No one knows. But anyway, it comes out of Somo. But you're being asked to assume that Somo, when they drafted the standard form of their letter of credit and added it to their standard form contract, the draftsman said to himself, what we are seeking to achieve is that the CBI alone will be the creditor under all these letters of credit. And then he said to himself, I know how we can ensure that. We'll draw them in favor of Somo. Well, that doesn't make any sense either. It really doesn't. It is simply not a realistic scenario. If the intention had been that the beneficiary of the letter of credit, the owner of the debt, was to be the CBI, or the CBI and SOMO jointly, nothing would have been easier than to fill in CBI or CBI and SOMO against the line in favor of at the very outset of the letter of credit. And the fact that the Iraqi or American draftsman of the standard letter of credit did not insert the name of the CBI in the normal, proper, and standard place for identifying a beneficiary of a letter of credit is, in our respectful submission, an unanswerable indication that the draftsman did not intend the CBI to be a party to the primary promise to which a letter of credit gives rise. And the fact that the draftsman went on to add a series of supplementary provisions specifying how the money due to the beneficiary was to be paid does not detract from the strength of that indication.
I mean, the primary contract is you present conforming documents and I will pay in accordance with your instructions.
Yeah.
What is the significance on your analysis of the fact that the engagement to honour the credit on presentation of the documents is owed both to the beneficiary and to CBI?
No, it's where the payment is to be made place. Where's the payment place? It's simply a promise being made, a collateral promise being made to SOMO as to how the debt will be discharged.
Well, it's more than that, isn't it? Because the engagement is to SOMO and CBI. So on the face of it, this is an undertaking that CBI could enforce.
So I beg your pardon? On the
This
face
is
of it,
an undertaking that CBI could enforce. The undertaking at the bottom of page 58, we hereby engage.
no, in my respectful submission, no.
They couldn't enforce it.
In my respectful submission, what the CBI could enforce was the promise that the debt owed to SOMO was to be discharged in a certain way, i.e. payment into a particular account. Not that the CBI could say, you owe us the money.
Well,
Do CBI have an enforceable right under the provision at the bottom of the second page as against the bank, the issuing bank? Do they have an enforceable right? Could CBI bring proceedings to stop them
well, just to
infringing the engagement?
let's suppose they'd wrongfully rejected the documents. Now, that in the ordinary course, it would be SOMO who would sue them for having failed to honour.
SOMO would sue in debt.
Well, now, in this case, suppose that CBI sued them for failing to honour the documents, an action for unliquidated damages.
Yeah.
Could they do that?
No, they could sue for damages.
Right,
But they couldn't sue in debt.
right.
And that's the difference. The difference is who is owed the debt under the letter of credit, to whom has been made an additional promise that the debt owed to SOMO will be discharged in a particular way.
Is the right to sue under that undertaking for damages itself a species of property which is affected?
Oh, it's a shows in action. It's a different shows in action.
Yes, but if it's a shows in action, is
But
it...
we're not seeking to attach it.
Is it... Yes, I see. You say that you are only seeking to attach
That's
the
the
debt.
point that we make. We are seeking to attach the primary debt, not the collateral promise. Now, suppose, for example, and you can see how this might arise, suppose, for example, what had happened is that the CBI had confirmed the credit, as they are asked to do, but didn't. And then the CBI negotiated the documents in Baghdad, paid SOMO. The CBI would then be the beneficiary of the obligation owed by Crédit Agricole to reimburse the conforming bank. And that would be a shows in action owed between Crédit Agricole and the CBI, and would certainly not be something which we could attach because CBI aren't our judgment debtor. So that's why it is very, very important to bear this distinction in mind between who is the debt owed to qua debt and what promises have been made, whether solely or jointly, as to how that debt is going to be discharged or paid.
So, in effect, what you're saying is that with regard to the CBI, the provision at the bottom of the second page, just going over to the third page, is as if there had been a separate letter sent by the issuing bank to the CBI saying, this is what we're going to do, a separate independent contract.
Everything gets done. And it may also be something that comes into play if there had been a confirmation, or indeed if there had simply been negotiation of a draft and the documents at the counters of the CBI in Baghdad. Because that's where the documents had to be presented, in Baghdad, at the counters of the CBI. Now, there is always a possibility, therefore, that CBI could say, well, we're going to act as a nominated bank. We will now take these documents, whether they're done on a negotiation, acceptance, or whatever. The money is now treated as paid to SOMO. SOMO's chosen action has vanished. We now have a chosen action under the terms of the UCP and this letter of credit, whereby we have a claim back against the opening bank, Crédit Agricole. There is no doubt that this is a badly, one might almost go to say incompetently drafted letter of credit, but many letters of credit are often difficult to understand. And the reason is it's trying to do a whole lot of things at once. Yeah. Because the CBI come into it as a confirming bank as well, and there are terms in it which are intended to deal with the situation the CBI might have confirmed. And you can see that if you look at electronic page 56.
Yes.
Where you've got
the last page.
An arrangement there as to what is to happen.
These are special instructions.
And you see at the bottom of page 55, special instructions to CBI upon receipt of your authenticating, confirming that you have taken up the documents. Now, they take the documents up and pay against them. And then they pass them on, they get couriered, and we, the CA, undertake to effect payment at maturity as per your instructions, and then they say how they're going to do it. Now, this is not what actually happened, because on this occasion, the CBI did not confirm. There are other occasions when the CBI has confirmed, and we have an example of that to show you, but the CBI seems to have been a little bit random in the way it did confirm, so this is, or not.
You say this special instructions is another, as it were, separate arrangement, not really part of the letter of credit as such, but a separate arrangement.
But it's part of the
Well, it's not between...
It's not between SOMO and the opening.
That's the point.
It is part and parcel
of the
bundle
yes.
of arrangements that a document that is 2.5 pages long contains.
But SOMO, it's not something SOMO could...
In a somewhat arcane fashion. But
it's not something enforceable as between SOMO and the issuing...
No, because the special arrangement is on the assumption
yes.
that the CBI have become, in effect, entitled to be reimbursed, either because they've paid out as confirming bank, or because they have paid out as a negotiating or accepting bank. And what your lordships might bear in mind is that under a letter of credit, you can have payment on presentation, which is documents presented, and you get site payment or credit. You can have deferred payment, which we needn't go into, but it's the same thing. You can have an acceptance credit, where you have acceptance of a bill drawn, and then that is accepted by the bank to whom it is presented, who doesn't have to be the issuing bank. And then you have a credit available by negotiation, where a nominated bank purchases the draft and documents. Now, all of those things can occur, and when they do, you have a separate set of relationships which will necessarily come into existence between the bank which has paid
Do you have a copy of that document?
this.
Perhaps, well, that's just indicating all the kinds of bank you can be, is that
Sure.
right?
This
Would
is
help me at least to have
my
it.
aid memoir.
So when I get back
But I can
to my
certainly
room,
give
I
you
may not be able to remember all these different
It's just notes made from reading Jack on documentary credits, but I'd be happy to give your lordship.
Thank you very much.
Okay.
Now, so if you have payment which is made not by the opening bank, but by the confirming bank, by a nominated bank, or by any bank to whom the beneficiary goes and says, I've drawn a bill here, would you like to accept it? And here are these documents, and I've discounted it, so you'll make so much percentage over the next month or so. In all those cases, a separate relationship will arise between the bank that pays, accepts, negotiates, or has confirmed, and the opening bank, because the opening bank is always obliged to reimburse. So you will find in a letter of credit, enormously amplified by the universal customs and practice, which you will then see go on for pages and pages, detailed provisions as to how those different relationships work, who has what rights and who can enforce whatever it is. Now, this letter of credit, in our respectful submission, is not happily drafted because it doesn't make it clear what's happening in various stages. But therefore, in our respectful submission, what you have to do is bear in mind, one, the vital importance of asking yourself, how, under the terms of this document and the UCP, do you identify the beneficiary, which is the person who is the creditor to the essential primary promise?
Can it include, as it were, an equitable beneficiary or not?
I beg your pardon?
Can it include, as it were, an equitable beneficiary? The thought comes to mind as a result of the use of the word beneficiary. It has to be the person with the legal right, does it?
The legal?
The legal right.
Contractual right.
It's a contractual right. So if you hold the right on trust for somebody in a better
Oh, no, my
that
lord,
won't do.
That's something that bankers hate.
Exactly.
Because
It's use of the word
letters of credit
beneficiary.
are documents, you pay in accordance with the document,
Right.
and as your lordship remember, there is authority, and it says in all the books, what we are not concerned with is the underlying transaction,
Exactly.
which lies behind the letter.
It's the unfortunate use of the word beneficiary that brings the point to mind, that's all. Yep, okay.
What you can do, I mean, you can have a transferable letter of credit.
Yes.
You see, in the UCP, you can have a transferable letter of credit, and indeed, you can assign the proceeds of a letter of credit.
Right.
I mean, as with any shows in action.
And once there's an effective legal assignment, that's
But
fine.
you can have a legal assignment, but
Right.
the one thing bankers throw their hands up in horror is the thought that there is some equitable right lurking around there about which they know nothing. And they say no.
Right.
So what we say, if I can, that there's a difference.
What's the reference to the standard document in our bundle?
The reference to the?
To the standard document, the UCP.
Wait, I'm taking your lordship to that in a
well,
couple
we'll-
of minutes,
we'll come
but
to
I
it
will
later.
give it you. Authorities Core Bundle, tab 1, page 1, electronic 1644.
Thank you very much.
But we're going to look at that.
Okay.
And not only that, I have an aid memoir usefully marked up.
I'm sure Lord Clark would like that as well.
Any cribs better than like none.
So what our submission is, there's a difference between two intentions that the opener of a letter of credit, or indeed the other parties to it, can have. Intention one, the money is to be due to X, and I will provide how and where that money is to be paid, and the discharge of that money due to X may be paid to Y, because of the discharge. Alternatively, the money is to be due to Y. In other words, the debt is to be due to Y. And there's simply a difference between those two. Now, there is in my respectful submission, my lord, at the start, to make what we would submit is an overwhelming point about whether or not SOMO were the beneficiaries and party to the primary contract. And it is this. A letter of credit is a rather strange contract. As you know, it's a unilateral contract of a sort. It doesn't require consideration. It's a contract. It becomes a binding contract as soon as it is notified. Even though at that stage the beneficiary has provided no consideration. It's not even analysed as a unilateral contract where, of a Carlyle and carbolic smoke ball type, where it becomes a contract when the beneficiary turns up and presents the document. And it's very important that should be so, because of course the seller wants to be able to rely on the fact there's a binding engagement before he's ever got near turning up and handing over the documents. And he doesn't want to be told, oh, it's been withdrawn or something like that. So you've got this peculiar contract, well understood in the industry, that as soon as it is notified to the beneficiary, the opening bank is bound, and there is a bilateral contract between opening bank and the beneficiary. And so you say, what in effect is happening is that the existence of this contract is being notified to the other party. That's why you have notification, which is carried out through the notifying bank. Well, it's rather important, obviously, that you notify the person you intend to contract with. And this is why, if you go back to our letter of credit, and whichever page you're looking at.
Which of the 3 pages, 1, 2, or 3?
54.
Page one.
Yes, please
Page
advise.
1,
So,
electronic 54,
Yep.
page 1.
Page 1.
Let's look at, this is a standard method of opening a letter of credit. Crédit Agricole, you can see sender about 4 or 5 lines down.
Yes.
They send to the receiver, Central Bank of Iraq. So this is a request addressed to the Central Bank of Iraq with a transactor. And then it says, here's the message to the Central Bank of Iraq. Please advise our following irrevocable documentary credit to SOMO after adding your confirmation. So now, when you look in the UCP, you will see all these terms are defined: the opening bank, the advising bank, the beneficiary. So what letter of credit, Crédit Agricole is saying, dear SOMO, please advise, dear CBI, please advise SOMO that we are undertaking an obligation to them in the terms of what follows. Now, that simply makes no sense then for my friend to say, oh, well, what was really happening was the CA, the Crédit Agricole was saying, dear CBI, we're promising to pay you, but go and tell SOMO to whom we're not promising anything. Just makes no sense at all.
Or we're promising you and SOMO.
My Lord, I'm very...
Or we're promising you and SOMO.
Well, you could say we're promising you and SOMO, but then you move down to the next stage. Well, you wouldn't use the advising bank to be a beneficiary, because you would then be muddling up at the end of the day entirely different roles.
Well, you could. It wouldn't be a very tidy thing to do, but there's no legal impediment if that's how you
I'm
phrase
sorry,
it.
Your Lordship's going to have... My hearing is not what it was, and Your Lordship...
You could assume an undertaking, an obligation to the advising bank. It might not be normal, but there are many features of this transaction that are not normal. But there's no legal impediment in favour against doing it, is there?
But then you could do, but then you would say we are undertaking a debt, the same debt, to you and the beneficiary whom you were advising. In other words, it's unusual, but it would be done with some degree of clarity.
I can see how you can say it's a slightly oddly worded provision, the capital letters under proprietary message, if it is to be interpreted as a irrevocable document undertaking to CBI.
Well, then the next oddity is after adding your confirmation, because
Yes.
the concept
That's what I mean.
of confirmation is that the advising bank is being asked to undertake
Right.
a primary liability of its own to the beneficiary.
Not the other way around, as it were.
The other way around. So you get, however unusual it might be, in my respectful submission, no banker would ever be willing to issue a document which in fact said, we are asking you to notify the beneficiary, and at the same time we're in effect undertaking the same liability to you, and please add your confirmation by which you will undertake the same liability to yourself.
Yeah, I understand that, but on the other hand, it is pretty odd anyway, because if you go to the bottom of the second page, the provision we looked at there is addressed, is an undertaking or engagement with the CBI, the very people who this is addressed to, in a way. So
That's the obligation that you undertake.
Quite.
That's the provision that you put in on the assumption that the CBI have taken up the documents, presumably as confirming bank, primarily. And then you say, this is how we will pay you back. And these are the terms which relate to our obligation to you as confirming bank.
Your point is that when
you have paid SOMA.
Your point is that when they want to enter into an obligation with the CBI, they spell it out, as they do with the engagement.
You always would.
So the only obligation to the CBI, which is not contingent on confirmation, is the one which begins, we hereby engage with the beneficiary of central bank, that documents drawn, etc.
Will be duly honoured upon presentation.
Right.
Yeah.
And you say that is collateral to the debt.
Yep.
It sounds in damages, and it is a distinct shows in action.
Yep.
Why isn't the previous paragraph?
Sorry?
Why isn't the previous paragraph also independent of confirmation having been added?
Well, the previous paragraph doesn't require that there be confirmation.
No.
Well, the previous paragraph is presumably simply saying, this is your account, you're presumably being, on your submission, SOMO.
Yep.
Your account with the Federal Reserve Bank in New York. Now, behind the scenes, that might actually be...
Well, that's what Lord Justice Morbeck held that your account is intended to mean your SOMO's account.
Yes.
And what often normally happens, is you will have a nominated account. I mean, it's necessary to have a nominated account into which payment will be made, because the days of bags of gold being handed over at the counters against presentation of documents are long gone. And so if the opening bank is to discharge its obligation, it has to know into which account payment has to be made, if it is going to make payment. Of course, if it's merely reimbursing a paying bank or a confirming bank, it's different. But that's why you will need identification for that. But if it's going to be paid directly after presentation to the beneficiary, then you need a promise to pay into a particular account.
The only YOUR in this document is right early on at the beginning under proprietary message, but that is addressed clearly to the CBI, yep. But that is before the terms of the actual letter of credit starts.
Well,
is that right?
But this is, no. Sorry, that is the letter of credit starts underneath that, because what it says, please advise following irrevocable documentary credit.
Exactly.
And then immediately after that, we hereby establish.
Exactly.
So that's normal form.
It's not quite true, though. It's not quite correct that the only other your is that, because in the following paragraphs, there are quite a lot of yours and yous.
Yes.
If you look on the foot of page 55, upon receipt of your authenticated telex SWIFT confirming, and then the next page, if our covered does not reach you in the second paragraph. So that's the CBI there.
Well, that's the CBI.
Well, it says so because the special instructions to Central Bank of Iraq.
Exactly.
But
So your can mean either CBI or SOMO, depending on the context.
Depending on the context. And again...
But why, in the paragraph beginning, provided all terms and conditions, it's a bit odd to use the word your account if you mean SOMO, because SOMO is referred to in the same clause as the sellers in the last lines. Contained in the sellers, that must be SOMO.
And then as the beneficiary in the next paragraph.
Well, of course, my lord, but
yes.
with great respect, this is pretty standard formulation.
Standard mess.
I mean, it's the standard way, because the documents that are required are inter alia, a seller's, now I think you'll find somewhere, let's have a look. The following documents.
So most duly signed
Well, that's
original
so much
commercial invoice.
commercial invoice. So if you've got SOMOs to find the commercial invoice, then seller means SOMO.
So SOMO is referred to as you, SOMO, seller,
Seller.
and beneficiary.
Yeah. And,
But it's
and I
been,
know
the whole
a-
clause provided all terms and conditions is a bit odd if it's, if your means SOMO. Why would you go to the trouble to assure SOMO, guarantee that, to SOMO that they will pay SOMO's account irrespective of any
well, it's
conflicting
not
instructions
SOMO's account,
from
it's-
SOMO?
It's this particular account.
Okay.
And that's the point, because of the arrangement that had been made under the UN sanction. Everyone had to agree that the money went into that account. And,
Well, you're using background now, aren't you?
well, I am. Well,
leaving
okay. Well,
background-
okay, well then leave the background out, and all you say is, it is not unknown, obviously, that in the case of a state trading organization, a particular account will be designated or will be used for all the money to go in. And it may well not be an account in the name of the state trading organization, because you're dealing with basically a governmental operation.
I mean, your basic point, I suppose, fallback position is that whatever your means, this clause has no higher status than the next one. We hereby engage. This is collateral, you say.
Well, not only does it have no higher status, it cannot override, in my respectful submission, what you might call the primary rules for identifying how letters of credit work. And the primary rule is that you start off with an opener who asks a notifying bank to notify, and the first thing that comes thereafter is, we undertake irrevocably to pay, and then you say whom you undertake irrevocably to pay in favor of. I mean, you've got by order of, which said shall under there, but in favor of SOMO for an amount. Now, that is the guts of a letter of credit.
But now, can you explain to me conceptually what is the difference between these two paragraphs, which you describe as a collateral obligation, and an assignment? What is missing that an assignment would contain or involve?
Because an assignment would say, I assign my debt to X, and give you notice that it's assigned to X. And you have to do that for an assignment, because that transfers the legal title. And the debtor knows who is now the owner of the shows in action.
And this, you say this isn't notice, this is just an instruction.
But, my lord, what happens frequently is that the beneficiary under letter of credit will have a collecting bank. And the collecting bank will have an account. In his name, usually, it could be in the bank's name, anything. And what he wants is the money to be paid into that account. And what happens to the money thereafter is up to him, but it doesn't turn the collecting bank into the beneficiary of the letter of credit.
But as I understand it...
I mean, any more than if I enter into a contract and agree with the other party that he will pay my agent, that simply means that he discharges his debt to me by paying my agent. It doesn't mean my agent becomes a party to the contract, or indeed the creditor.
I thought that your submission was that the reason why, at any rate, the paragraph beginning, we hereby engage with the beneficiary and the central bank, the reason why that is not an assignment in your submission is that an obligation to honour documents drawn in compliance with the credit is not the same as the debt. And therefore, it's not an assignment of the debt, it's referring to a different obligation sounding in unliquidated damages. I thought that was your submission.
But complied with. Sorry.
The paragraph beginning, we hereby engage with the
Oh, sorry,
beneficiary
the one
and
after
Central
trial,
Bank of
but yeah,
Iraq.
we hereby engage with the beneficiary and the central bank. Documents drawn under and in compliance will be duly honoured upon.
Yes. My understanding of your case
Yeah.
is that you are saying that there are two distinct choses in action. One is the debt, the other is the obligation sounding in damages to honour documents as presented in conformity with the credit. On that, if that is correct, I take it that your submission is this isn't an assignment because it's referring to the wrong shows in action.
Yeah.
And I understand your submission about the preceding paragraph to be that is an undertaking referring to SOMO's account, coupled with a statement which effectively means and no other account, whatever you may subsequently say.
Yeah. Well, indeed. No one can.
So they're entitled to reject subsequent instructions.
Yeah.
Actually, we've changed our banks. Will you send it somewhere else?
Yeah.
Where, as far as credit agricole is concerned, where is presentation going to take place? Is it in London?
No, Baghdad.
It's Baghdad.
Baghdad.
Wait a minute.
And the Lordship will see that on the first page,
Yes.
electronic 54.
Yeah.
So that's I see. So,
Paragraph numbered 1.
so that's presentation that central bank will pay on behalf of. Yes.
Sorry, immediately above that, against presentation of the following documents at the counters of the Central Bank of Iraq for negotiation. And then it says for negotiation, which again is a wonderful example of how this credit works in strange ways, because as far as one can tell, nobody ever negotiated these documents, or they were never negotiated. So what used to happen, as a matter of practice, as we know, is that SOMO would hand over the documents to the CBI, who would check them, who would send them to Crédit Agricole, who would check them, and Crédit Agricole would then instruct its correspondent bank in New York, which was JP Morgan, to press the relevant buttons to produce a transfer of electronic credits and debits within the Federal Reserve clearance system in New York. That's how it worked. So electronically, a debit would ultimately turn up in Crédit Agricole, and a credit would ultimately turn up in the Federal Reserve. Now, why they put in for negotiation, why they put in confirmation, it may be that over decades of use, this got used in different ways, but by the time we get to our stage, when these letters of credit were issued, that's how they worked. That's
The
how
problem
they were
about letters of credit is that they are formulaic and that they are produced by cobbling together a series of standard phrases.
Exactly.
Which have been hallowed by long
And what upsets bankers is anything
Not necessarily
apart from the standard
uniformly
phraseology. Mainly because you want your issuing clerk, and you say clerk, and it's not a bad clerk, it's basically you have people who do nothing all day and are trained to do nothing all day, but issue these in the credit issuing departments of big banks. And what big banks don't want is anyone departing from the normal, because that creates difficulties, or can create difficulties. But what we do, going back to my point, it is our respectful submission that if you have a document which says, please notify SOMO that we are opening this irrevocable credit, then it says in favor of SOMO. That is only capable of one interpretation and must override anything which may appear to be inconsistent thereafter.
And what's the bit that's blanked out after by order of?
But by order of, that's by order of Shell.
It's a reference to the...
I mean, it's a reference to the people who asked for the letter of credit to be opened. It's only been crossed out, I mean, for confidentiality reasons, but it says Shell Singapore, I think.
So much for
Or
confidence.
Shell Far East.
Yeah. Yes, I see.
Now, so with respect to Lord Justice Briggs, And I just give you the reference in the Court of Appeal judgment where he says this. It's Electronic 2720,
Yes.
which is Core Volume 2, Tab 8, Paragraph 58 of the judgment,
Yep.
where he says the guts of the letter of credit is to be found in these two paragraphs on the second page. With respect, he is wrong. The guts of a letter of credit is the promise by the opening bank to pay a named beneficiary. That's what it is. And that is invariably to be found at the very outset of every letter of credit one has ever seen. Now,
So it's really from we hereby establish down to the date of expiry. That, to your mind, is the gut of the letter. As I
beg your lordship's pardon?
From we hereby establish down to the paragraph dealing with expiry. That is the core of the letter of credit as you presented.
The core is right at the beginning.
Yes, thank you.
Just going back to the paragraph which began, "We hereby engage," as regards the beneficiary, that's a further valuable confirmation that this letter of credit means what it says. As regards the Central Bank of Iraq, which was intended or might have added its own confirmation, does it mean anything more than we, Credit Agricole, will pay you insofar as you are the people who've disbursed? We will ourselves honour the same presentation to you.
Yeah.
It's the same sort of thing as appears under the special instructions, isn't it? Yeah. But it's really the previous paragraph provided that, which creates the unusual feature of this letter of credit.
Now, the words...
If the obligation is to pay CBI, in what respect does that differ from a debt owed to CBI?
If the obligation, but we say it isn't. The obligation being undertaken is a promise to the CBI that the debt owed to SOMO will be paid.
Well, as I understood it, I may have misunderstood you. Your answer to Lord Mansell's question was that that the paragraph beginning, "We hereby engage," is an undertaking to pay CBI.
It's a promise to the CBI. No, then in that case, I didn't answer correctly. It is a promise made that the debt will be discharged.
Right.
The debt that is owed to SOMO will be discharged, and in particular, that it will be discharged by paying into a specific account, the CBI's account, the account held by the CBI at Federal Reserve, New York, because SOMO doesn't have an account. Now, so our submission is the guts are to be found where you have the primary obligation, not to be found in additional provisions which relate to the manner in which the money is to be paid. Now, the words "in favor of" are hallowed by long usage, and their effect and meaning is spelt out in the Uniform Customs and Practice, which, as your lordships probably remember, not only contain the practice of bankers and so on, but are incorporated into the contract as binding provisions. Now, if your lordships could look at the UCP, your lordships will find it in your lordships bundle, in the Authorities Core Bundle, tab 1, page 1, electronic 1644. What I have done is simply had copies made up in which the term beneficiary is highlighted, so your lordship can see from the number of provisions which require things to be done to, by, or on behalf of the beneficiary, how important it will be to make the system work, that the identity of the beneficiary is clear. So, thanks.
Thank you.
Now, that's why it's an aide-memoire for that purpose alone. I haven't marked anything else up. It's just so I don't have to take your lordship in boring fashion through saying, here's another example of the word beneficiary appearing. Now, if your lordship could go through page 1 of the UCP, you will see
What, on 60?
And just to see, it's 1644 electronically.
Yes.
Under forward, just tells you where it comes from. Under the second paragraph forward, which starts ICC,
Yeah.
you will see halfway down, the objective since then was to create a set of contractual rules that would establish uniformity in that practice. So the whole object of this is to have an incorporable set of contractual rules. And in our letters of credit, they are expressly incorporated, as your lordships will see somewhere.
To be
Sorry?
55 second draft.
55. Yes, 55, immediately under the second of those two paragraphs we've been looking at, subject to the UCP, etc. Now, if you look at the top of UCP, page 1647, page 4 of the bundle, end of the first paragraph under application, they are binding on all parties thereto unless expressly modified or excluded by the creditor. You then have, which is vital, a series of definitions. Starting off, advising bank. In this case, that was the CBI. Beneficiary means the party in whose favor the credit is issued. Confirming bank, defined 3 down. Then you have what to honor means. You've got cite, deferred payment undertaking, acceptance. Then issuing bank, that's Crédit Agricole. Then you've got a definition of negotiation. Nominated bank, which is the bank where credit may be available. And then underneath, presenter is a beneficiary bank or other party that makes the presentation. Now, Article 3, there's an important one for our argument about citus, mark as you go by.
Yep.
5th or 6th down, branches of a bank in different countries are considered to be separate banks.
Yep.
Now, I leave your lordships at your leisure to go through looking at the number of occasions on which beneficiary pops up and which indicate how important it would be to know who the beneficiary is. Now, there are just a couple of points that I wish to focus on. You will see Article 9,
Yep.
which is electronic 1650.
Yep.
The obligations and what happens for the advising bank. A credit and any amendment may be advised to a beneficiary through an advising bank. By advising, the advising bank signifies that it has satisfied itself as to apparent authenticity, etc., An advising bank can use another bank. So in this case, the advising bank is the CBI. That's where they come in, and it makes little sense to talk about the CBI advising a beneficiary who is itself. In other words, the whole concept is the advising bank advises someone else. Then you've got confirmation, which is the preceding page, 1679, Article 8, and you go through that, and you say, if that happens, it makes no sense to treat the CBI, if it confirmed, as being also the beneficiary. As I say, it's absurd to suggest that it's being invited to confirm to itself. Now, for your lordship's reference, an example of a case in which the CBI did confirm will be found in Appendix 3A. Hang on. I have it. I no longer have it. Appendix 3A, tab 4, electronic 773, where you have, and that also shows you what it is the CBI does when they carry out their obligation to notify. This is the document. That's a tab which shows you, give you a series of notifications by the CBI, in all of which, except one, they decline to add their confirmation, but in the last one they do.
Yes.
So we would suggest that once you read that, you see that on Lord Justice Briggs's analysis, Crédit Agricole promised to pay the CBI, who promised to pay themselves, and who promised to advise SOMO, who were not being promised anything. Because under the Lord Justice Briggs analysis, SOMO aren't parties to any obligation at all, except possibly, I suppose, you have to say, the promise that the money would be paid to the CBI. It just doesn't work. Now, would you also look, please, at Article 18, which your Lordship will find at electronic 1654.
Okay. Yep.
Because this tells you what has to be done about the commercial invoice. Your Lordships will remember. Yep. And it says, 1, it must appear to have been issued by the beneficiary, except as provided in Article 38. Article 38 deals with transferable letters of credit and is irrelevant. Therefore, if this is to be applied, and it has to be applied in this case, the only way these letters of credit could be operated is if you have the beneficiary issuing a commercial invoice, and the only person who ever issued a commercial invoice in all these hundreds of transactions was SOMO. And the idea that the CBI ever issued a commercial invoice is absurd. They couldn't. And so that also demonstrates how Lord Justice Briggs' analysis just can't work, because you immediately run into the buffers on something like this. On every single occasion, you've got non-conforming documents.
What's the reference to the invoice? We have the invoice, do we?
Do we? We probably do.
Okay, well, no.
I'll try and find one for you. Now, yes, no one has ever suggested, hitherto, for what it's worth, that anyone other than SOMA were the sole beneficiaries of these letters of credit and were the only people able to sue. And when I say no one has ever suggested, that was the case being put before Mr. Justice Field by Professor Sarushi and Mr. Dar explicitly. And the reason they were doing it at that stage was their case then was, SOMO has state immunity. It's an emanation of the state of Iraq. Acting sovereign authority has immunity. Therefore, they say, you're suing the state.
Yeah.
And it was put expressly, and you could see it halfway through the argument when it wasn't going that well. There emerged an idea, well, maybe it's SOMO and the CBI jointly. But until this case, no one was ever suggested, SOMO or anyone else, that they weren't the only people who were parties as beneficiary. Now, if it had been the intention of anyone, particularly SOMO sellers, to provide for a letter of credit to be issued in favor of CBI, nothing could have been easier. You just put the CBI's name next to in favor of.
Yeah.
And if they wanted to have a transferable letter of credit or they wanted to assign, they could have done that.
Can I just ask, is there any provision in the UCP for the assignment of a benefit of a letter of credit?
39. Article 39, which is at 1665. But it's the assignment of the proceeds, yes. The fact that it is not stated to be transferable shall not affect the right of the beneficiary to assign any proceeds to which it may be or may become entitled under the credit in accordance with the provisions of applicable law. But it relates only to the assignment of the proceeds.
So the proceeds, does that mean the money in the account?
The money.
Once it's been paid.
It's a faintly odd idea, is it? Can you say that you address a letter of credit to one person, but as you read through it, it becomes assigned?
Becomes assigned.
Which is the effect of the interpretation on one view.
When you say assigned, my lord, no.
No, I'm saying if that's the effect, it's rather strange to have a letter of credit addressed to SOMO and then later to find it, as it were, being assigned.
Well,
which is the effect of the
Your
argument
same
against
document.
you.
With great respect, your lordship is using assigned in the wrong sense, because an assignment
I'm making a
means
point in your
transfer
favour.
of a piece of property.
I'm making a point in your favour, Mr. Paul.
Oh, sorry, I do beg your pardon. I've always been very bad at that, I'm afraid.
Well, you probably wisely assume that anything put you
I'm so
may. But what I'm suggesting is that if there's a suggestion that there's an assignment, it's rather odd, although letters of credit have their many oddities, no doubt, to have a document or a contract between A and B, which in the course of the terms of the contract becomes assigned to B and C, or alternatively C. That's the point I'm making.
There has been, it has been, hitherto, at least, common ground between ourselves, that no assignment took place.
Yeah.
This shows in action. No security interest was created in it. No equitable interest under any known system of law.
Well, you say equitable interest is irrelevant.
Sometimes you get yes, well, you're quite right. Equitable interest wouldn't matter. But it might matter. Well, I suppose if you got an equitable interest in the proceeds, would that prevent execution against the shows in action before they became proceeds? You get a difficult question there, but no one has ever, that's never been run. The argument has been run on the basis, look at the letter of credit. Is the debt owed to SOMO alone, to the CBI alone, or to them both jointly? And on the answer to that turns the case. And
you accept, do you, Mr. Pollock? I mean, again, this is looking at the background perhaps, but if the proceeds had reached the account of UCI, they wouldn't have belonged to UCI, they would have belonged to the government of Iraq at that point.
No, they would have belonged to the Federal Reserve of New York. There would have been a shows in action, which is a debt owed by the Federal Reserve of New York to the CBI, and the CBI would owe internally some duties, no doubt, to the government of Iraq. I mean, the CBI would actually be presumably an agent at that stage, because no one would suggest that the CBI are going to be beneficially interested in these monies. They are simply the route by which money comes in and gets distributed to the various ministries and so on in accordance with the budgetary arrangements of Iraq.
The CBI are a branch of the state, are they?
Well, that's a good question. A central bank is an agent of the state, but
well, it may be an agent.
Sorry?
May be an agent.
May be an agent.
Not everything a central bank does is done on behalf of the state.
It is not an emanation of the state.
No.
And that is very important, which is one of the reasons why, of course, it has a special immunity against execution status under the State Immunity Act. So you can't just say, the CBI is the state. The CBI is an agent of the Iraqi state for the purpose of holding money, passing money on, doing this, that, and the other. But we all agree that once this money got into the Federal Reserve,
SOMO didn't have any interest in it.
SOMO probably wouldn't be allowed to do anything with it. Some of it might go to SOMO because SOMO had to get paid money. The way SOMO worked, as we've seen on the evidence that was put in, was they didn't keep any of the proceeds, but they were put in funds by the government to meet all their running expenses and all the rest of it to do their job. Now, some of that money may have derived ultimately from the proceeds. It doesn't matter. None of that matters.
The point is that this would not be SOMO's money once it hit
once
the account.
Once it got into the bank, it's gone.
It's gone.
As far as we're concerned.
But you say that you can get it at any point up until that.
Well, there is obviously a conceptual difference between, or an actual difference between a shows in action, which is a debt, and the proceeds once the debt's been paid.
Undischarged debt.
Entirely different things.
An undischarged debt and the proceeds are not the same thing.
No, exactly. Now,
so you say it needs to be assignment or nothing, effectively, which is how it proceeded in the Court of Appeal.
So
it needs to be effectively assignment or nothing.
No, not assignment. No one says it's assignment.
Right. Well,
the way it proceeded in the Court of Appeal was SOMO is not a party at all.
No.
To the promise to pay. Only the CBI is, and it's not because it started with SOMO and been assigned. The argument that has been put is, from the outset, it was intended, and my friend says it's a mere error, and trying to read letter of credit too literally, to look at in favor of and say, oh, well, the UCP says that's beneficiary, that must mean it's a promise to pay.
I appreciate, Mr. Pollock, that you're saying it's not an assignment, but I think it's also your submission that if it's not an assignment, there's no relevant interest
Yes.
by anybody else but SOMO anyway.
Yeah, that's right. Now,
So what's the point? What is the point of the undertaking, or of any undertaking to CBI to pay to CBI? I suppose your answer is that there isn't any such undertaking. It all turns on the meaning of the word your.
Yeah.
But do you have a position if your means CBI?
if your means the CBI, it's very, well, the only way you could try and make sense of it, and I'm really not sure that it works, is to say that it's a paragraph that's intended to operate where the CBI have confirmed and paid. But that particular approach was rejected by Lord Justice Moore-Bick.
Well, it would mean that there were two different instructions relating to that situation. One in the paragraph beginning provided all terms, and the other in the paragraph immediately under special instructions to Central Bank of Iraq.
Yeah.
And that would seem slightly strange.
And all you can say,
Well,
I mean, without trespassing upon background, you can say, as a matter of generality, in the case of a state trading organization, it will always be a desire that money is channeled from letters of credit or from earnings into a particular account, which will be a state account. And a state account will usually be held by the central bank. And because, I mean, and if you ask yourself, well, why should this be? One answer is, you don't want money being diverted in a corrupt fashion. You want the money getting back to the government. And one way to ensure that your state trading organization and its employees don't stick money off by giving instructions for things to be paid in the wrong place and hoping it will be buried in the accounts is to make quite sure that all letters of credit require the money to be paid in a certain way and no variations. That makes sense. Now, we would submit that one of the difficulties of that one way of analyzing my friend's argument is to say, is that he is saying that a promise to discharge a debt due X by making a payment to Y, a debt due to SOMO by paying it into account in the name of CBI, automatically and without more substitutes Y, the CBI, as the creditor. Now that simply cannot be true. It's not a sustainable proposition. I perfectly well accept that an obligation to pay a debt due to A into the hands of B can be part of an arrangement involving a transfer of the debt or the creation of an interest in it. And we've seen that, where the creditor owes money to someone else and enters into an arrangement that the money owed to him must go into a certain account and so on, so that someone else can get his hands on it in order to pay himself off. Now, there's nothing like that in this case, and you have to prove that that arrangement existed behind the scenes, and whether it would affect a letter of credit is another issue. But nothing like that is alleged or has been alleged here. So we needn't spend time worrying about that. So our case is the point made by my Lord Sumption a minute ago. Ownership of the shows in action created by the letter of credit is entirely separate from ownership of the proceeds. Prior to the money reaching the CBI account, the shows in action remains in existence and is owed by SOMO alone. It hasn't been alienated, whether to the CBI or anyone else, and therefore it is capable of being intercepted while that shows in action is still in the ownership of SOMO. Now, can I move on to point or issue 2?
Yes.
Citus. Now, this is intellectually very exciting.
What we've been hearing so far is...
Lord Collins knows all about it, I understand. Anyway, so my lord, that was point one
Thank you.
we've dealt with. I'm moving on to point two, issue two, citus. Citus of the debt. Because if the debt is not cited, or it doesn't have a citus within this jurisdiction, then third-party debt order, garnishee, goes out of the
So
window.
you need to win this point.
So I know, because then there's equitable
Yeah,
receipt.
subject to the receivership.
But apart from that, yes. And third-party debt order is the easier way to go, usually. So this argument arises on the assumption that SOMO alone is
Yes.
the beneficiary, the creditor, and therefore the owner of the shows in action. Now, just remember that when one is asking where a shows in action is cited, you're not asking in what jurisdiction. You're actually asking yourself where, as a physical place, usually an address.
Yes.
And you need to best bear that in mind. Now, a system of law needs a rule or rules to establish the citus of shows in action, because it is often relevant to jurisdiction, execution, transfer, creation of securities, all the rest of it. English law has adopted a simple and straightforward general rule for the case of debts. The citus is the residence of the debtor, where the debtor, it's because that's where the debtor may be found, and therefore where he may be sued by issuing process in the local courts, serving it on him at his residence, and where it is likely that he will be able to execute against his property. The rule is well known, it's in Dicey, and has been for a long time. It's set out succinctly, if you want it, as a reference by Lord Hobhouse, quoting the relevant
Can you have
passage.
more than one residence?
Sorry?
Can you have more than one residence?
That's it. Yeah, we get there. You certainly do. Can. And there have to be rules for that. But the rule is set out by Lord Hobhouse, quoting Dicey, in the Société Eram case, which your lordships find in the Core Authorities bundle, tab 7, at page 157 of the bundle for the quotation, electric reference 1800, 1800. Now, I'm not going to read it now. It's well known and it's there.
Right. Thank you. Right.
Now, there are obviously going to say practical advantages in having that rule, because you can serve, you can enforce, you get judgment, etc. Right. So one asks oneself rhetorically, what are the alternatives to that rule? And one that is suggested is the place of payment of the debt. That starts off with the problem, what happens if the place of payment isn't specified? And you have to infer, you have to have another rule. What are the advantages of the place of payment?
Well, if it's not specified, the rule is surely that you have to find the debtor's residence.
Creditor has to
so you simply arrive by another route.
Seek out the debtor, so you get there, but then you may have arguments. And as my Lord Clark says, what happens if there are several relevant residences? Now, because the creditor can have several residences. Now, if you ask what are the advantages of the place of payment, apart from an occasional suggestion that it's convenient for the creditor, it's difficult to think of any. Now, if a debtor has two or more residences, two or more houses, two or more places of business, which is an obvious risk with a large bank, you have to have rules to decide which is the relevant residence.
Yes.
Now, with banks, it's very easy, because the rule that has been laid down is you ask where the account is kept, at which branch of the bank was there expressly or implicitly a promise that that is where debts would be honoured.
That ties in with the fact that
Where you've got different branches. So in the case of a bank, you're basically asking at which branch of the bank was the account held in that case, and it's easy, and that's easy to understand. Now, the possibility of a debtor with multiple places of business is a clear characteristic of the situation relating to banking credits, since banks often have offices in different places. And since both merchants and banks are keen to minimize the possibility of argument and difficulty, the issue, as we have seen, of multiple bank branches is regulated by the UCP. The codification of good and acceptable practice is that, which is invariably incorporated into a letter of credit, says Where a bank has more than one branch, each branch is treated as a separate bank, as a separate entity.
Yep.
So that means for the purpose of this case, it is very simple. Crédit Agricole, the issuing bank, is deemed to be a single bank and has a single residence, which happens to be in the City of London, and therefore the situs of this debt is not a difficulty because of multiple branches. In fact, there's no proof, there's no evidence that Crédit Agricole even have a branch in New York, although one guesses that they probably do. So a combination of the established rule and the UCP produces a perfectly simple and satisfactory solution to the question, where is the situs of a letter of credit debt? At the residence of the opening bank. Now, that has advantages, obviously, to the beneficiary. If it's dishonored, the beneficiary wants the ability to proceed swiftly and easily to enforce his debt, and he knows where to go, where the bank that opened it lives. And we would suggest it's difficult to see any advantage in departing from that rule. Prior to 1981, there had been no suggestion that letters of credit were subject to any special rule relating to the situs of debts. And the question of situs arose in that year, and has only arisen once in England, in the Power Kerber case. Power Kerber, the National Bank of Kuwait, Core Authorities, Tab 5, Electronic 1756. Now, let us find this and look at it, as this does leave a little bit of thought. The facts were these, my lord. It was a sale of goods case where the seller, the manufacturer and seller, was in North Carolina. They sold goods in Kuwait, and the relevant buyer was, would appear, the agent or distributor that they used in Kuwait. So it wasn't your actual user, ultimately, it was the distributor. Now, on the sale in question, the letter of credit was opened by the National Bank of Kuwait in favor of the sellers to be notified via the Bank of America in Miami. And payment was to be made via the North Carolina National Bank, presumably in North Carolina, although some people have suggested there are doubts about that. The facts are not as clear as they might be. The buyer, the agent distributor, took proceedings in the courts of Kuwait to attach the benefit of the letter of credit. And it would appear from Lord Denning's judgment that this was done because the distributor said he was owed commission by the sellers. There doesn't seem to have been any allegation, I don't want to pay because the machines are bad or don't work. It's that he said he was owed money, a separate debt. And so he went and sought to attach. And the court of Kuwait granted that attachment, which I suspect was a provisional one. The sellers then started proceedings against the National Bank of Kuwait in North Carolina. But they discontinued those proceedings, apparently on the ground the courts of North Carolina didn't have any jurisdiction. National Bank of Kuwait wasn't there, wasn't carrying on business there, and whatever the rules about jurisdiction in North Carolina, they weren't met. So those proceedings were discontinued. At which point the sellers started proceedings in London because they discovered that the National Bank of Kuwait had registered a place of business under the Companies Act. And so they said, we can serve them here. The bank represented, the bank then came in, Mr. Longmore, and said, we have been prohibited from paying under this letter of credit by the courts of Kuwait, where we have our headquarters and live, and where we issued this letter of credit. Kuwait is the situs of the debt, therefore we're bound by it. Now, this point as to where the situs was, and it's something one just has to say, was dealt with in the most extraordinarily cavalier fashion. by Lord Denning and Lord Justice Griffiths. Quite extraordinarily cavalier. And I will suggest, without hesitation, that it is a rather disturbing example of what one would describe as judicial imperialism, which in those days was much more common than it is in our modern, quieter times. Now, if your lordships turn to the judgment of Lord Denning,
Yes.
which is electronic 1759,
Thank you.
page 1236 of the report.
Yep.
Lord Denning says, this case raises an important point in international trade. It has nothing to do with England except that an action has been brought here. And that was a very true statement. And then he describes the facts, which I have outlined to your lordships, and I think that's reasonably accurate. And then he goes on to the letter of credit on the next page. The letter of credit is dated Kuwait, issued by the National Bank, Miami, North Carolina Bank in Charlotte, and you then see the standard, and you see down the bottom, page 4, your negotiations, which is actually I think, addressed to another bank. Anyway, the goods are shipped. You had a usance draft. You go on, the order made in Kuwait on page 1762, and this is where you see commission. It says, here's that in early November, Hamoudeh, he is the buyer, filed a claim in the courts of Kuwait against Power Kerber for 50,000 Kuwaiti dinars. That's about 180,000. We do not know the nature of the claim, but it is thought that it may be a claim for commission.
Yep.
And then he goes on, he recites Power Kerber started proceedings, they were given up. Then summary judgment was given. And now you can see, this is the guts of it, at page 1763. Mr. Longmore argues, letter C, the provisional attachment gives the bank an arguable defense. Proper law of the contract was Kuwaiti law. Payment of sums alternatively says the lex situs of the debt was Kuwait. Well, they dismiss the proper law point in the next paragraph, and then these 6 lines then deal with the situs at letter F to G. Nor can I agree that the lex situs of the debt was Kuwait. It was in North Carolina. A debt under a letter of credit is different from ordinary debts. They may be situated where that's ordinary debts, may be situated where the debtor is resident. But a debt under a letter of credit is situated in the place where it is in fact payable against documents. I would hold that Parker J. was right in giving summary judgment. So that is the sole reasoning in Lord Denning's judgment to say that letters of credit are different. Turn over the page to 1765 electronic, and you have Lord Justice Griffiths, who manages, I think, half a line longer. And at G, he says, secondly, it is submitted that payment was unlawful according to the lex situs of the debt, which it is said is Kuwait. But this is a debt that is owed in American dollars in North Carolina. I do not regard the fact that the bank that owes the debt has a residence in Kuwait as any reason for regarding Kuwait as the lex situs of the debt. Well, that's, well, what do you say? Lex situs of the debt is North Carolina, and this ground for giving leave to defend cannot be supported. So neither member of the majority, my lord, made any attempt to approach the issue as a matter of principle or to embark on any reasoning.
Mr. Justice Parker had taken a different view.
No, he'd done the same.
Well, I see.
I think.
Do we have his judgment?
Did he give any reasons?
No, we don't have his judgment. No, I thought that the way Lord Justice Griffiths expressed himself sounded as if it was a ground.
No,
I see.
As I understand it,
Because they do allow the appeal.
hang on. No, Mr. Justice Parker had given judgment for the plaintiff.
Yeah, but
imposed the stay, that's all.
Well, his decision was affirmed, wasn't it?
Yes,
no,
his
it
decision
was.
was
Well, the
affirmed.
appeal was allowed, but the cross appeal was dismissed. I see. This was the cross appeal. Yep. This was the cross.
It was a cross.
Do we have Mr. Justice Parker's judgment?
Sorry, my lord?
Do we have Mr. Justice Parker's judgment?
No, I've never seen it, my lord.
It's not reported anywhere.
It's not reported.
It's not recorded as reported.
My lord, it's an Order 14
Yeah.
summary judgment. This is only in one weekly law report, so that's all. No, you certainly wouldn't have reported his. So, as I've said, neither member of the majority made any attempt to embark on any reasoning as to why the usual rule should not apply. It is simply asserted. It doesn't apply. Or, Lord Judge Griffiths doesn't even say it doesn't apply. He simply says He asserts that the debt is in North Carolina. At least Lord Denning says, well, we're going to establish a separate rule for letters of credit.
Was there any comment? Has there been any comment in the books about this case?
Well, the comment goes as follows. It depends how you... Dicey says, well, here it is, and it can give rise to difficulties. The difficulty being, of course, that you couldn't sue in North Carolina, which, if that's where the situs of the debt was, might be regarded as a disadvantage. Apart from that, all of the books simply report this as the decision and therefore the rule. There is no real discussion, and all around the world, if you look at their books, they just say, see power curve. It's the only case that's ever been decided, and this is the first case, as far as I can tell, in which it has ever come up or been challenged on this point.
Might it be said that even if it was, as it were, wrong or a departure from normal principle, it's now been around for 36 years, and all the books say it's the law, and the common law historically may rather develop in that way?
That might be said, but it would be wrong.
Right.
And the reason it would be wrong is because that rule that sometimes is cited about not disturbing established authority is because people have entered into transactions in reliance on it. Now, I cannot believe that anyone has ever entered into any letter of credit transaction in reliance on the correctness or otherwise of the Power Kerber decision. And the fact that very few people ever have to sue in circumstances where the situs matters. I mean, the situs at the end of the day is only really going to matter for jurisdiction purposes or for execution purposes.
Well, it only matters if it's suggested that the debt has been appropriated in some way, whether by assignment or, for instance, by nationalisation or asset blockage orders and so on.
Well, those are quite important factors, aren't they? I mean, one knows in the context of arbitration that quite a lot of arbitrations have been upset by people persuading their local courts that is the arbitration debtors, the award debtors court to interfere. Isn't that likely to be a problem in this area if we say that the situs is the place where the letter of credit issuer...
No examples of it having happened.
No, but perhaps that's because hitherto the situs has been regarded as being at the place of payment.
So your lordship is adopting a modern robe of judicial imperialism. In other words, we, the English, should have this rule so that we can prevent other courts from behaving badly.
No, I wouldn't put it like that, but I would suggest...
what it comes down to.
I would suggest that the common law is quite pragmatic. Letters of credit are an exception to the rule about consideration, as you accept, and so on. We don't actually always insist on carrying logic to its ends when there's a good reason not to.
Well, you have very little difficulty with arbitration awards because the Arbitration Act allows you to register an award as a judgment and enforce it. And as your lordship knows, under the New York Convention, it is very, very difficult indeed to prove that the arbitration award isn't valid and shouldn't be enforced. And to take a good example, I mean, I don't know if your lordship remembers the Court of Appeal decision in the Russian...
Don't worry if you don't.
UKOS.
In UKOS, exactly. Yes.
In the UKOS case, I mean, the local courts, you may say, behaved very badly, but that didn't get them anywhere because none of that fell within the New York Convention. English courts said, no, we're not going to look, that's bad behavior there. These awards are valid, as did the Dutch courts.
Yes.
Right up to the Dutch Court of Cassation. So the answer is there's not really a problem in my respect for submission. And apart from anything else, no one suggested that there was a problem which required this rule to be produced. Now,
Mr. Creswell...
can I just have...
Mr. Creswell must have produced the rule from somewhere. We haven't got his arguments, but he was an experienced banking lawyer.
He didn't produce it from books. He didn't produce it from authorities because those would have been cited. It was probably made up by Mr. Creswell. Nothing wrong with that. I mean, not saying that was a bad thing, but I mean, that's what happens. But one point for my Lord Newberger. I would say to your lordship, the Mandarin Star and the Salem Now, there is an example. Your Lordship may remember the Mandarin Star Court of Appeal said the concept of takings at sea has been misunderstood for a long time. If your master, who is moored off a port, decides on his owner's instructions to sail away because they've got a claim against you, that is a taking at sea and Lloyd's must pay. And that was Lord Denning, Court of Appeal all said that. And that stood for years and years and years. Along come the Salem. Lord Denning said, oh, no, I got it wrong. We went to the Lords and said, look, this has stood for years. And people have written policies on the basis, your Lordship's then House said nonsense. It was wrong, it was always wrong, and we are going to extirpate it. And they did. It's just, the point your Lordship makes is that there are as many examples of cases where the House of Lords has overruled a bad decision, or as cases where they've said, oh, this has stood for a long time, we won't.
What the effect of citus is that if, unlike this case, the courts of the jurisdiction were persuaded to annul the debt, or the legislator was, that would be valid. So that if you adopt citus, you do adopt a situation where the local legal system, and you agree, you say this is an imperialistic thought, but the local legal system may effectively undermine a letter of credit payable in America.
Think of the Russian banks. I mean, why did we have so many cases in the Court of Appeal in the 20s where people said, look, these damn Russian banks annulled this, stolen that, etc. And the courts of this country said, and so be it. That's where the property, whether it shows as an action or jewels belonging to Princess Yusupovsky or whatever, are located. You have to have a rule, and you have a rule. And if you have a rule, the courts or the legislature of the country where property is located may take it. They may nationalize it. They may nationalize it for good reasons. And it is not the function of this court and this jurisdiction say, well, we don't like that, so we're going to shift the citus.
I mean, the context in which this...
Why don't we establish a new rule now, saying all debts are not cited at the place where the debtor lives?
The context in which this usually arises in modern conditions is asset freezes, particularly relatively recent legislative asset freezes by the United States, successively against Iran and Libya, both of which gave rise to litigation in the United Kingdom. Now, it's very clearly established that if you owe a debt under a bank account, no letters of credit involved, the only place where an American asset freeze will be honoured is a case where the account is kept in the United States. If it's an account in London, then the English courts will say, we don't care what the American legislation says. Now, this decision suggests that you would have to distinguish, presumably on some rational ground, between a debt owed by a letter of credit and a debt owed on just about any other basis imaginable for the purpose of deciding what the effect of an American asset freeze was. Now, one can see that if there is something special about a letter of credit which gives rise to different considerations from other debts, that may be a justifiable thing to do. Presumably we will be hearing what the special justification is.
Indeed. But I'm going to demonstrate, I hope, why, in fact, considerations point the other way. It's a very quick point. Now, what I should, before I get to the, very quick illustration I have, could I ask your Lordship, before we move on, to look at Mr. Justice Waterhouse, who was the dissenting member of the Court of Appeal, electronic 1767, where immediately after B, he says, a debt is generally looked at as situated in the country where it is properly recoverable or can be enforced, and it is noteworthy that the sellers here submitted voluntarily to the dismissal of their earlier proceedings against the bank in North Carolina. We've been told they did so because of doubts about the jurisdiction of North Carolina court. which was alleged in the pleadings to be based on the transaction of business by the bank there acting by itself or through an agent. As for the question of residence, the bank has been silent about any residence that it may have within the United States of America. In the absence of any previous binding authority, I have not been persuaded that this debt due under an unconfirmed letter of credit can be regarded as situate in North Carolina merely because there was provision for payment at a branch of a bank used by the sellers in Charlotte, and I do not regard the analogy of a bill of exchange or a security transferable by delivery as helpful. And it seems to me, my lord, that Mr. Cresswell must have used that analogy of those two. But apart from that, no arguments, no material, nothing was put forward. So at least there you have a consideration in principle. Now, what I want to put to you is this, that the disadvantages of the rule adopted by the majority are all too apparent in that case itself. And I can illustrate it this way. The debt was situate at a place, the debt was held to be situate at a place where the debtor had no apparent connection and where he could not be sued. That is a starting point, isn't a good starting point. As a result, the debtor was sued in a jurisdiction, England, which was not his primary residence, and found himself the subject of two conflicting orders. The courts of his primary residence had ordered him not to pay. The English courts, chosen as the result of a forum shopping exercise by the plaintiffs, have told the debtor to do what his home courts have forbidden him to do. That's the result. This is not a desirable result, and it can only come about because the English court, yielding, as I have suggested, to a tendency to judicial imperialism, decided to invent a rule which would disconnect the situs of the debt from the residence of the debtor, and therefore the place where the debtor was likely to be amenable to jurisdiction which could impose its will upon him, namely his home state, his home courts. So look at the position that the National Bank of Kuwait was left in by this case. There is at least the possibility that the agent who had attached the money in that case proceeded in Kuwait, obtained judgment, and then said to the Kuwaiti courts, please execute against the National Bank of Kuwait because this money was owed to me. And under our Kuwaiti law, yes, it's mine. You've held. I'm entitled to attach it.
Was Mr. Justice Waterhouse wrong as well, then?
No. Well,
because on your argument, exactly the same problem arises about his judgment. He accepted the citus was in Kuwait, but he said, I would have thought correctly on a general principle, that the existence of the debt is not affected by a local order that it not be paid as long as the local order didn't discharge the debt.
Well, he was.
So he was wrong too.
Yeah. No, the result was wrong on everyone's part.
Why is it wrong?
That was a different point, wasn't it? That was because of the substantive provisions of Kuwaiti law and the terms of the attachment order.
Yep.
I think
what Mr. Justice Parker had done, which one would submit was sensible, was to say, well, I'm going to stay execution until we see what happens in Kuwait.
No. I mean, that would be contrary to the House of Lords decision in National Bank of Greece and Metlis, wouldn't it?
Probably.
I think it would be.
I'm willing to accept that.
Well, the whole point was that the Greek government was trying to avoid paying the central bank paying this debt, and it issued all sorts of injunctions, and the English court said, sorry, the proper law of the debt is English, and you have to pay up.
And if the proper law, we will give judgment.
Yeah. So I think there is a problem anyway, but anyway.
There's a problem anyway.
That didn't depend on citus, as I understand it. The National Bank of Greece and Metlis, along with the Adams litigation that had preceded it, did not depend on citus. It depended entirely on proper law and on the effect of a universal succession under the law of the jurisdiction where you were incorporated.
I think they had two rounds, didn't they?
The
first round, they
had
tried
two
just
rounds.
to stop payment, and the second, they introduced some sort of universal succession to try and...
It's so long since I read that case. I think the last time I read it was in the tin
Well, maybe we'll have to have another look at it. But anyway,
I
you
would
say
have to
basically the
have to go
principle
and-
is
Wasn't that the case that Mr. Lippman was in?
No,
Or was that another
I
one?
don't think so.
Was that Adams against another?
I think Mr. Lippman wasn't old enough in 1954 and 1956.
Oh, well, then it's different. There was a case that he was in involving National Bank of Greece. Anyway, be that as it may, whether or not there were other aspects of this were wrong.
So what does Mr. Justice Waterhouse say on our point?
On the
point we're considering?
well, that's between B and
yes,
D.
but what does he actually say?
Well, what he said was, I dissent from Lord Denning and Lord
Yeah.
Justice Griffiths. The citus of the debt is Kuwait. Because, he said, that is the general rule, and no one has offered me a principled reason for departing from the general rule in the case of letters of credit. That's it. That's what he said. Now, what we are saying is that to adopt a rule which has the potential for putting a bank in a situation of having two conflicting orders, in other words, the Kuwait court saying, no, we're attaching it because it's here, and the English court saying, we're ordering you to pay because we say it's here, is undesirable. And you avoid that, on the whole, by adopting a rule which says the citus of the debt is the residence of the debtor. That it minimizes the risk of conflict. It doesn't do away with the possibility that the courts of the debtor or the legislature of the debtor will do bad things and so on, but that's life. And you can't do anything about it. What you shouldn't do is adopt a rule which splits residence and citus in a way which makes it possible for a bank to find itself the subject of conflicting rules. So, in our respectful submission, your lordships ought to declare the majority to have been in error, unless my learned friend can persuade your lordships that there are really good sound reasons for distinguishing letters of credit from any other form of debt, and there we are. In modern commerce, after all, the opening bank will almost certainly be found in an established commercial center with a developed system of law and enforcement, and the location of the opening bank is often likely to be the most important consideration for the beneficiary of a letter of credit. They want a nice bank in a good place. And you needn't worry about Kuwait anymore, because now you've got, if not Lord Justice Evans, other people, Mr. David Steele and others, who will make sure that litigation there is conducted in a proper way. Now, I don't know, Your Lordship, of course, a lot of argument about place of payment often says, well, it's an important thing. And one of the reasons for this is that people still have in their minds the idea that someone turns up at a bank and is given a bag of gold in return for something. Of course, it doesn't happen. And nowadays, the place of payment is really in an electronic world, not really a matter of enormous importance. So I said, just so your lordship have the references, as I said to your lordship earlier, the CBI informs Crédit Agricole that the proper documents have been presented and those are sent to London, at which point Crédit Agricole in London sends a telex to JP Morgan, which brings about this transfer in the books of the Federal Reserve. You can see this happening, if you want to see the document that brings it about, in Appendix Volume 3A, Tab 11, at page 124, electronically page 871.
871.
Appendix 3A, as I say, tab 11. And this is a standard form that goes, you can see, top left-hand corner, the sender is Crédit Agricole in London. It goes to Chase US, that's JP Morgan Chase in New York. And you then have an account with institution FNY US 33, and then the various things, beneficiary institution, Iraq Oil Proceeds. Now, the reference to thereunder to please pay by FedWire, FedWire is one of the 3 clearing systems that exists in New York, and it's run by the Federal Reserve in New York. Your lordships will have heard of CHIPS and others, and if your lordships have any interest in seeing how those 3 work, there is a statement from an expert banker, Mr. Boston, to be found at Appendix 3C, tab 2, page 15, electronic 993. Now, it's because of an understanding of things like that that my respectful submission, Mr. Justice Field treated the giving of instructions by Crédit Agricole in New York as the act of performance. And although Lord Justice Morbick disagreed with that, Lord Justice Morbick found in our respectful submission accurately that the payment rather, the characteristic performance took place in London by the triggering of this system by sending the email. That was decided by Lord Justice Morbick in case the issue of proper law became relevant, which so far no one has thought is, I think, particularly relevant. But there we are. My Lord, next point. Honest dealing. Very quick. Again, the assumption is that Somo alone is the owner of the shows in action constituted by the debt, no assignment or anyone else creating a proprietary interest in it. Now, the other side say, but there is some doctrine called the doctrine of honest dealing, which means that you can't attach this because the CBI have an interest. And they refer to an authority, the General Horticultural Company ex parte White House, Core Authorities, tab 3. Now, I'm not going to spend any time really other than to say that case, as Lord Justice Morbick has held, goes no further than this, that if a man has created a proprietary interest in a piece of property in favor of a third party, he cannot honestly deal with it. That seems obvious, because it's not his own, and since it's not his own, it's not available for garnishee. And that's an end of it. And we would agree that's right. But there is no proprietary interest created in this shows in action. And that equally is an end of it, as Lord Justice Morbick says. So,
Would we get to an equitable interest here, then?
how do you get to?
An equitable interest. You've dismissed any relevance for an equitable interest in relation to the first point.
If you had an equitable interest, it's got to be
that would
an
suffice.
equitable proprietary interest.
That
yes.
would suffice,
Yes.
But you say CBA has absolutely no interest.
They've got no interest in it.
It comes back to the point that until the money goes in the account, they have no interest. They merely have a contractual right.
The honest dealing, there are a couple of cases prior to General Horticultural, which were relied on by the Court of General Horticultural, all of which involved proprietary interests. And in the subsequent case, Rogers and Whiteley, yes, the illustration given was equitable because the suggestion was there might have been, the property in question might have been held in trust. There might have been a trust interest in property in the bank, in a bank account. If you've got an equitable or proprietary or legal proprietary interest, then you can't honestly deal with the property by giving it to someone else because you are seeking to override or give away a third party's property. That's all the rule comes to. And it has no application in this case.
What about a bare contractual right? You accept that there's a bare contractual right?
That doesn't create a proprietary interest.
Yeah.
And the other side they might get around that by referring to the third party's Rights of Contract Act or whatever it's called, but that got nowhere and has been dropped. So now, can we go on to equitable receivership? Because if I can get there, I will win my bet with myself of sitting down before the adjournment.
If it's a bet with yourself, you'll also lose it.
Sorry, my lord?
If it's a bet with yourself, you'll also lose it.
Well, I know, but
Anyway, yep.
of course. But that means there's satisfaction both ways.
Anyway,
Equitable receivership. Your lordship will find the relevant judgment in the Court of Appeal in paragraphs 29 to 38 of the judgment of Lord Justice Morbick. You'll find that in Core Volume 2, tab 8, pages 129 to 132, electronic 2712 to 2715.
yep.
Now, it is common ground on the basis of the decision in Masry, and particularly a judgment of Lord Justice Collins in that case, that there is nothing to prevent an English court granting a receivership order by way of equitable execution, even if the situs of the relevant property is outside the jurisdiction. So that is not an issue. 3 points were considered by Lord Justice Moorbeck as to why it might or might not be proper to grant it in this case. Point 1 is paragraph 33 on electronic 2714.
Yep.
In the present case, the person against whom the receivership was made and subject to the order is Somo. It has no presence within the jurisdiction, no connection with this country other than as a person against whom judgment has been entered as a result of a process to which it was not a party. That's not quite correct. It is a party because it served on them. You go to court and ask for leave to serve Somo out of the jurisdiction with your application to be entitled to enforce the arbitration award as a judgment. That, after a lot of toing and froing, was served on their solicitors within the jurisdiction, Vince and Elkins. They were served, and they then entered an appearance. So to say to which it was not a party is perhaps not quite right. It has not sought to have that judgment set aside, and the judgment was entered after it had been served. It has merely challenged the third-party debt orders and the receivership on the grounds that the court had no jurisdiction to make them. And you've got to be very careful there. The challenge was sovereign immunity, solely sovereign immunity. And the point was put, we are an emanation of the state, therefore we are immune from any form of adjudicative, let alone executionary jurisdiction. And if your lordships look at the relevant forms, as you know, if you enter that and it isn't upheld, then you are deemed to have entered an unconditional appearance, which is what they have. And so they haven't tried to set it aside on any ground. And the truth of the matter is, the way the Arbitration Act is set up, there are no grounds for setting it aside, unless they came in and said this award had been set aside by the courts of the seat, which oddly enough was Baghdad, although Mr. Hunter decided the case sitting here. But everyone agreed the seat was to be regarded as Baghdad.
Seat of the arbitration.
The seat of the arbitration. So for current purposes, this is a proper application made to the court. Judgment has been entered against a party which was before the court and was properly before the court, and they have not objected to the fact that they were before the court or that judgment should be entered except on immunity grounds which have been dismissed. Anyway, Lord Justice Moorbeck comes on and says, its connection with the jurisdiction is tenuous unless it can said to be the owner of a debt which is situated in this country, and for the reasons I've given, I do not think that is the case. Well, agreed. The reason we're going under receivership is only if the debt is said to be cited abroad. Now, our answer to this, my lord, is, if you look at the context, Lord Somo entered into the international oil market, requires payment by letters of credit. Somo must be taken to know very well that there's every chance that the sale contract or the letter of credit will have contacts with one of the world's major financial centers, whether it's London, New York, or whatever. Somo has year-long contracts with Shell. Shell always issues its letters of credit through London, through the CA. Somo specifies arbitration as a method of dispute resolution. Somo is aware, presumably, that there is a powerful international policy to the effect that awards made in the context of international commerce should be readily enforceable around the world. England has given effect to that policy by enacting in the Arbitration Act 1996 that judgment can be given on a valid arbitration award. Section 66 has given the English court specific power to give leave to enforce and then enter judgment. That power has been exercised in this case, and there is no longer a challenge. The policy behind the 1996 Arbitration Act is to render awards readily enforceable, a policy that is shared internationally, as one can see from things such as the New York Convention. Now, that policy makes little sense unless it carries with it a willingness to enforce the judgments that you then give. And therefore it must follow that part of this policy to which this country subscribes, that arbitration awards should be readily enforceable, not only by granting a judgment but by executing, is that you should allow execution. You should allow the judgment to be enforced. And therefore, I would submit that in considering the connection for the purpose of between, if you like, the judgment debtor and the jurisdiction, when one comes to consider granting an equitable receivership order, an international arbitration award stands in a rather special position because of those policy considerations. One would ask rhetorically, what is the sense in saying that we have power to enter judgment against someone such as Somo because of the arbitration award, but it doesn't provide a sufficient connection with the jurisdiction to allow use of the tools which England has for the enforcement of that judgment. So, in our respectful submission, the lack of connection between Somo and the jurisdiction, Mr. Lord Justice Morbick's point 1, is really not a good one. His second point, which you find paragraph 34,
Yep.
I don't need to deal with because it's in my favor. He asked himself the question, would it be an exercise of exorbitant jurisdiction to grant this? No, he said, inter alia, because I think English law under the Rome Convention is the proper law of this letter of credit. So, no problem there. The third point, and which he found against me, is over the page, paragraph 36. Finally, he says, there is the question of the effect of the receivership order on other parties, in this case principally CBI, which is not resident in this country and is not a party to the proceedings, but is the beneficiary of a promise by Crédit Agricole to pay the sums due under the letters of credit account in New York. A receivership order would effectively prevent it from obtaining the benefit of that obligation. Now, with respect to Lord Justice Morbick, that really is reaching somewhat. Any form of execution which intercepts the debt before it reaches Somo will have the effect of depriving CBI of the benefit of the promise that discharge of the debt would be by payment into a particular account. Bear in mind that this whole argument is taking place on the assumption that the CBI has no interest in the shows in action, has no proprietary equitable interest, and is merely the recipient of a promise that the debt to Somo alone will be discharged in a certain way. Now, if Lord Justice Morbick's approach is right, you're effectively saying that a promise that the debt will be discharged in a certain way acts as a form of immunization against execution if that promise is made to a third party as well as to the debtor, and that can't be right. In our respectful submission, it is implicit in any promise that a debt will be discharged by payment in a certain way. It's implicit that there must be a proviso subject to it not being legally intercepted en route. That must follow. Inherent in any promise you make is subject to not being prevented by the law, whether it be execution or any other reason. It wouldn't even involve a breach of Crédit Agricole's obligation owed to the CBI, if equitable receivership order was executed, because they would say, well, we were prevented. The courts of England stopped us paying it into New York, and that is always going to be a good answer. It goes even more in this case because Article 36 of the Uniform Customs and Practice would excuse Crédit Agricole if they didn't pay to Somo. You've got a force majeure clause in there. Any other cause beyond the control of the bank. What more do you want? So, of course, the CBI are deprived of their promise, the benefit of the promise. The benefit of the promise isn't worth anything. I mean, if the CBI sued, what would they get in terms of damages? Nothing. There are no damages that they've suffered. You can't understand that. So, if the CBI has no proprietary interest, it's impossible to conceive that they could have any complaint let alone a cause of action against Crédit Agricole, if Crédit Agricole were compelled by whatever legal means the court adopted to prevent the money going any further, to prevent the debt being discharged. There is no evidence, I would just suggest there is no evidence that the Court of Appeal, that the Crédit Agricole regard themselves as at risk of being prejudiced if the receivership order goes through. But if they do, since the order has been given without prejudice to their right to come and argue in due course if they want to, they would hereafter have every opportunity if they thought it was going to do them any harm. But apparently they don't. So our respectful submission is there is nothing to prevent a receivership order being given. And it ought to be given, because that gives effect to the policy of this country to allow arbitration awards to be enforced. That's it, my lord. Oh, wait a minute. I wouldn't worry. Now, just in case I forget at a later stage, perhaps I should just say now, in due course, we would wish to submit to your lordship in writing something on costs, if we ever get to that stage. But my junior
You're right, the rules
my
require
junior
you
said,
to
don't
raise
forget
it,
to
but-
mention that, but I do, because the courts below have made special orders as to costs.
Well, the sensible thing is to deal with costs in writing, as you say, after you see
But
our
that,
decision.
that'll be at a later stage. But anyway, I put my marker down.
Perfectly fair, thank you. Thank you very much, Mr. Pollock, thank you. Mr. Blackwood? Would you like 5 minutes, or would you like to start your submissions at 2?
I'm in your hands, my lord. I'm very happy to start, but I'm equally happy if you wish to adjourn.
We might as well adjourn then and resume at 2. We are somewhat ahead of schedule, to put it mildly, so we'll do that. Thank you. Resume again at 2 o'clock. It's now adjourned.